Ms. Imam, you give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning back. You can never take this off. Do you understand? How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to 3 days in jail, give you credit for 1. I'm going to suspend your license for 90 days.
We'd ask that go, I guess, have a retroactive application to the suspension that she served from by way of the ALR suspension.
Why?
Well, she's trying to, what's your question? Why, Judge? I'm sorry, I couldn't.
The thing is, reward someone, especially for behavior when she's doing whatever she wants to do.
No, it's not a reward. It's to make sure that in a situation where she doesn't have a bunch of financial resources, that she can get to school and to work, and she's doing things to move forward in life. And she is enrolled full-time. She's got 13 hours in an engineering program, got a pharmacy tech license. She's working as a pharmacy tech, but also maintaining home. So the costs and the process of getting a lawyer to represent her in an occupational license setting be more difficult. She's got her license active now. We asked that suspension that she served, which was a 6-month suspension.
How bad was it in the PTI program? Did she repeatedly just test positive for alcohol and dope?
No, I think there were missed. I don't think there was any positive tests. I think there were just no test, skip test.
So I have, yes, it's a failure of to report and failure to enroll in SOP and failure to maintain.
Did she do anything?
And she's been on an ankle monitor since I got the case, and she's not had any issues with ankle.
And then also, as counsel mentioned, 31 skip tests on the report. So it does not appear that she did much of anything that was required.
We disagree with that assessment, but
I mean, reasonable minds can differ. You know, there's also a matter of the $3,000 surcharge as well. What are we going to do with that?
weigh that in light of her financial circumstances.
Do you see what I mean? It's like one gift, but it is though. I mean, there's no jail time. She got booted out of the program. Now I'm not suspending her license. Now I'm rolling the $3,500 that she would normally pay. It's one gift after the other.
It's not, and here's why, Judge. The legislature came in, and I know the remedy is citizens go vote, but a $3,000 surcharge to an individual who has little to no money is a catastrophic amount financially.
Well, we do it. We give a 2-year payment plan, so it comes out to like $30 a month.
And we saw how the surcharge program worked for individuals, and it destroyed their license. And so what happens is then they come back to your court because all of a sudden they don't have a license valid, and then it plugs up our system with Class B charges of driving with license invalid cases. And so it's not a reward. It's understanding that me, as working a full-time job,
here's what I'm going to do.
Different financial position.
Here's what I'm going to do, Mr. Garris. I agree with you about the money, because to me, the money I don't care about money, but what I care about are actions. And I really like it when people better themselves. It makes me happy because I want you are a woman in this life that society, life is more difficult just because you're a woman, just because you're a person of color. Life is more difficult. You need to be dependent on no one, and you should get your education. You should get a good job so that you never have to rely on anyone. You be strong, I'll make you a deal. Like, I want to know, you're telling me that she's enrolled in all these things. If she is, and you can show me that she's in school, she's doing this, I'm going to take the money away, because I don't care about the money. But as far as the license suspension goes, if you show me that she's actually in all this, and you can show me, I'll acquiesce to you, because I want you to do well. I want you to leave here better than you came. You've not shown me that so far, though, right? You've not done well here. So why continue to do this? But if you show me that you're bettering yourself now, that you're in school, like you're saying, you're working as a tech there, I'll do it for you. Yeah. Show me, I'll acquiesce.
Thank you.
But in this life, you should never rely on anyone. I have 2 daughters, and the first thing that I'm teaching them is never rely on anyone. You go to school, you get your education, you get a great job, so that You can just rely on yourself and you can always be on your feet. You can always make money because when you get that education, no one can take it away from you. And you can always go get another job. That's what life's about. And this, knowledge is power. All right. Please. So the 3,000 and whatever the court costs are. Okay, you ready? Yes, sir.
Judge, I'm here on William Thompson. It's a TWI that the state is going to hopefully be dismissing.
It's not old.
We're supposed to, I don't need to approach?
No, it's 118 days, right? No. I mean, once it gets to like 180, then yeah. No. Good to see you, Mr. Lockwood. Yeah, thanks. Ready?
Yes.
Come on up.
I'm back on Mr. Castillo, PC here.
All right.
Yes, Judge. So in
Enlighten
regard
me.
to the crossing the parking lot, it was the officer's understanding, I spoke with the officer, that crossing the parking lot is a violation because he crossed right through, and the traffic code that we found is transportation code.
Hold on. Did you take a look at this?
Judge, I'm very familiar with the statute they're quoting.
Okay, what is it?
It's section 545.423. And it's crossing property, and it states that an operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle. And the officer said that he crossed, according to the DIMS, he crossed straight through onto the public roadway. And speaking with the officer, he repeated that as well, saying that he was at a slow roll and he just went straight through upon noticing the officer. And that's whenever he performed the traffic stop, as he crossed that parking lot.
Operator may not cross a sidewalk or drive through a driveway, parking lot, or business or residential entrance without stopping the vehicle.
Yes, Judge. And as the
He never stopped at all.
correct, and as the DIMS states, the vehicle pulled into the parking lot and exited the parking lot in an attempt to navigate away from the patrol vehicle. So he just entered and exited. He didn't stop.
First, Judge, that statute requires that you're doing it for the purpose of avoiding a traffic control device. There's an additional element.
Really?
Yes, Judge, if you look at the statute.
Hold on. There's only, it says, so that what I read was A. B says an operator may not cross or drive in or on a sidewalk, driveway, parking lot, residence, or residential entrance at an intersection to turn right or left from one highway to another highway.
In order to avoid the traffic control device.
Correct, but that looks like it's an or, not and. Or, unless you show me, unless you can show me differently. I mean,
It is an or, Judge. I agree with that. However, may I address another issue?
of course.
If you listen to the DIM summary, he says he intended to stop my client to begin with. Then my client, in order to evade him, rolled across the parking lot.
Good. As the
There's no explanation as to why he started attempting to stop my client in the first place. I recognize, of course, that police have many and multifarious functions, but activating emergency lights and attempting to stop somebody for some unexplained reason.
I didn't hear that.
well, Your Honor, the DIMS reads
It's certainly interesting.
It reads different because it says while the officer was patrolling, he observed the vehicle, and it immediately goes into how the vehicle pulled into the parking lot and exited in an attempt to navigate away from the officer's patrol vehicle. And after that point, it says the officer initiated his patrol lights. So he wasn't attempting to stop him at the point that he entered the parking lot. All the officer articulated was that he was attempting to navigate away from his vehicle.
I mean, what it sounds like to me is he sees the officer and just tries to get away, do something that's maybe a violation of the transportation code and pulls him over right there. Had he kept driving and just gone straight, perhaps would have never been pulled over. But the virtue of the fact that you go and do that, if there wasn't a violation, I would kick it all day. But I mean,
May I address one other very shortly?
please.
The way he says in his DIM summary, he says, the purpose for crossing is to evade me. he is thinking this man is trying to evade me. And that certainly implies that he was trying to stop the defendant before the defendant started and turned into the parking lot. Otherwise, why would he say he was trying to evade me? In other words, if he's consciously thinking that would lead the defendant to evade.
I agree with you.
So without showing as why.
I agree with you. But the fact remains is he went through. And it looks like he may have indeed violated that part of the transportation code. Now, pull the video. If the video shows you something differently, come back and we can do PC again. You know, I'm always happy to revisit it, but perhaps if he would have kept going and not done anything, not done that, he wouldn't have gotten pulled over. If he would have and nothing had done, there had been no errors, then you know what would have happened.
Understood.
I'm going to find probable cause for now. What was the last name again?
Castillo.
Castillo. Okay, Mr. Castillo, I'm going to find probable cause. And let me tell you, you speak English, right?
Sir.
And by no means does this mean that you're guilty of this offense. This just means that there's enough to go forward now. That's all it means. You got a great lawyer who will handle the case for you. If there are always any issues, you guys can come back and reapproach and we can go from there. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond. Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive.
It's eligible, Your Honor.
Great. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in contact with Owen. He will tell you when you have to come back to court. If Owen tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay. I'm going to have you sign your receipt. Victoria will have you get with Maddie for your bond conditions, and then you guys are free to go. Thanks. Of course.
Right this way.
Why come back? Why come back if you knew? You know what I mean? I don't. So, well, I mean, he's not ready regardless.
I mean, yeah, I read the probable cause a little bit more, and it is pretty egregious for the state of the children, but obviously that goes to public safety and not so much the flight risk part of it.
Right. And that's, they'll address that when they get there. Right. I want to know, is he going to go back?
Well, and I specifically asked the sheriff's office, not the DA, because they can't get a hold of, or you can't get a hold of detective or the 88 on the flight risk part of it, because she was pretty emphatic on the phone asking for no bond, but she didn't clarify regarding the self-surrender part. And so I emailed the extradition specialist and she hasn't gotten back to me. My guess is she's contacting the same people that we're contacting at the office. Amy's already left 3 voicemails at different.
You want to roll it to tomorrow?
Judge, so the unknown should not go against my client. He's presumed innocent. He was coming back to notice of this because he is in custody.
I don't know that.
And also,
They haven't proved that he knew it.
but the burden isn't innocence. This isn't a criminal charge. This is an administrative charge, and it's public safety, and it's and flight risk.
You're mentioning different things that you don't have information on. The burden's on the state to prove that he needs to be in custody. You haven't proved that. You haven't told them why it's public safety risk. You're saying that you're waiting on 3 calls, people to call you back. My guy is sitting in jail while you do this. He's got a right to go turn himself in. We're asking for a bond.
I disagree, Your
There's no
Honor.
right.
Right.
There's no right.
In terms of,
I don't have to give him a bond.
right.
There's no right. This is not an entitlement.
He's in custody. He's got a right to go turn himself. There is no public safety concern. They haven't proved there's a public safety
But the
concern.
extradition statute is that he doesn't have constitutional right to bond because it's not a criminal case. It's permitted by the court, but it's not a basic default for an administrative charge for fugitive and so it's not the same. The code itself specifically states that, with the exception of death penalty cases and life in prison, is that the court can permit a bond, but he is not automatically granted one because he's not being charged with a crime. It's an administrative charge for a fugitive case that he's already been apprehended on. So it's a different burden, and it's not, yeah.
Would you be amenable to one?
So right now, no, just because the nature, and I understand it's both that the court would like to hear on, but regarding the public safety part, because he had these people, vulnerable people in his care for such a long time, and the abuse is at least until November. The warrant obviously wasn't signed by the judge until December 20th, and the warrant was live December 25th, is that because of the extent of it and the fact that he recently went, I know
You
it's
know
not.
when he took off to Australia?
don't.
Do you know when?
Over there, and the warrant came through on the 25th. On his way back into town, he got picked up. He didn't get picked
You
up
don't
on
know
the way
when
out.
he went there though?
He told me he went there to celebrate Christmas with his family over there.
And my thing is, and obviously this is the part that I'm trying to confirm, but the detective here, after the original patrol officer followed up, is that the detective talked to him at length regarding these abuses. And so what I'm trying to figure out is either during that initial questioning or after the warrant went live, the detective said, hey, don't leave America or don't leave Colorado. He then did that, then obviously that becomes a pretty big issue. I understand regarding the return part, but the fact that he fled, obviously, if someone with a badge tells you, hey, don't run, and then you leave America.
Can't imagine that they're going to tell him that.
There's no proof of that, Judge.
I can't, I mean.
Well, that's what I'm trying to verify. That's what I'm
saying.
saying. I don't have that information, which was my point.
When officers have enough to arrest someone, they just do it, right? They're not, I don't,
Meaning on the circumstances, and obviously I'm not licensed in Colorado and I don't work in their DA's office, but there are circumstances where they have the probable cause, but it's stronger with an arrest warrant versus whatever situation landed in the first place. So I couldn't say for sure, and we're trying to get a hold of ADA prosecuting it right now to figure out why. So the short answer is I don't know, which is why I'm trying to get more information.
how long do you think you'll be ready till you go forward?
Well, since we left voicemail messages in 3 different agencies at 2 different levels, hopefully by the end of today. But for what it's worth, he's already waived. So if he's revoking it, then we can go by way of governor's warrant, but
Judge, we're talking about burdens. This is what we do every day. This is what we argue for every day.
Crap, I still need to go to court 3. Totally forgot. God dog it.
I mean, if,
Hey,
are you about
you
to,
just don't have time.
right, will you be returning today or what did you?
No, yeah, I'll be returning. I totally forgot.
Do you-
I gotta go.
Okay,
God dog it. So let's wait till we come back. If we don't have anything, then
that's to see if anybody else can contact back. Because I assume everybody has a boss. And so if I can't get a hold of the original detective, hopefully his, I don't know what they call it, sergeant or lieutenant, or somebody can shed light on it.
I'm confused as to what's going on. Is he coming back? or-
Yeah, he's coming back.
Okay.
Yeah. So, because she's left voicemail messages with this person, the extradition specialist, and the detective. But yeah, so it's not clear after the original conversation what,
Right.
yeah.
I get it. All right.
So I don't know. I mean, because I've agreed on bond before.
hey, thanks for being patient. Hey, Hadi, how are you, man?
We're just talking about different smoking techniques because Ricardo's thinking about getting.
Yeah, I need my smoker.
Ricardo's thinking
Yeah,
about getting
smoke them if you got them.
gravity fed smoker, and so I cook like 7 ribs at once.
Oh, that kind of smoker.
Yeah, mine
Yeah.
I thought you were talking about cigarettes.
No,
brisket.
Man, way off.
Yeah, yeah.
Okay, so,
Unfortunately, I can only present what I have and nobody's called me back. So unfortunately.
but you can't, I mean,
I know.
you're asking 3 agencies to call you in an hour. That's not feasible and that's just not enough time.
Anyway, but that's all I have to present. So
What do you think about giving them a bond?
I mean, ultimately, you're right. I don't have enough to argue for the flight risk part other than the inherent nature of it being a fugitive case. But it's just with
If he would have been in Australia and they extradited him back, that's one thing.
well, that's
No.
a different pickle. And we actually have someone that handles just international extraditions. And I haven't worked on any personally, but I know that's a whole.
What I'm alluding to is that he's back on his own accord, whether he knew or whether he didn't. Regardless, it doesn't, my only concern is if he goes back or if he doesn't, if he goes back or he doesn't go back. And you're old enough to know that actions have consequences. I'm going to set you a bond now. It's not going to be a low bond, but I'm going to set you a bond. We give you 14 days from the date of your release to go back to, is it Denver?
Adams County, my understanding is Denver.
Okay. If you don't go, you're old enough to know that actions have consequence, and the consequence is that I'm going to revoke this bond. I'm going to set it at 0. I'm not going to give you another one, and you're going to lose all the money that you paid here. Do you understand? Now, according to Murphy's Law, what happens? If it can happen, it will happen. So don't wait till the last day, because I don't care if you come back here, kicking and screaming, oh, well, I had a death or I had this, my car broke down. I don't care. The minute If you try to get on a plane, they're going to arrest you again. So you need to make other kind of travel arrangements and get to Denver as quick as you can. You understand? Now, what's an appropriate bond?
Judge, I would ask just to have enough skin in the game, considering he doesn't have any criminal history, considering he was on his way back. It's not like he was running for a year, 2 years. The warrant came through on the 25th of December. We're at January, what's today, January 7th? So I would say 2,500.
I would.
I think that's pretty low considering it's a serious felony.
Well, that'd be, he's got to pay 100%, so that would be a $25,000 bond in other courts. Since he's got to pay 100%, it's $2,500.
I was gonna say, because there's two, and I don't want to rehash everything, so just vulnerable complainants and the extent of the accusations for the period of time of the abuses that we ask for 10,000. So.
And Judge, the idea is not for him to go back and continue working before taking care of this. The idea is he goes back and takes care of this and gets some orders in place so he can continue working if the concerns are that where he's working, there's vulnerable people. So if he gives you a bond.
No. My only concern is that he goes and turns himself in.
Yeah.
I don't care what you do. I don't care where you go work. I don't care if you're going to hang out with Jesus. The only thing you need to do is you need to go turn yourself in. That's the only thing I'm ordering you to do. That's what you need to do. Now, he wants a $10,000 bond. He wants a $2,500 bond. I'll set your bond at $6,000. Okay. If you make the bond, you need to go from the time that you make bond, I give you 14 days to go turn yourself in. Now, you need to also understand this, is that they're going to make travel arrangements to get Denver to come pick you up. And that can happen. For you to be able to bond out, you have to withdraw your waiver. You now have, how many days credits do you have so far? Let's see, you got arrested on
I had to reset my computer.
the 7th, it looks like, right?
Yesterday.
Right. So you have around 2 days credit. If you withdraw your waiver to go post that bond, you lose those 2 days. You don't have to make a decision now. I'm just telling you what happens and the consequence of you wanting to make bond, because I don't know if you're going to make it or not. If you want, we can roll you to tomorrow or the following day so you can reach out to your family to see if you're able to make the bond. And if you are, okay, then you do it. I will let you guys talk about it and you tell me what you want to do. Okay?
Thank you, Judge. It'll take 3 minutes to get a decision and I'll let you know.
Take your time, no rush.
All right now, if he chooses to do so.
Appreciate it, Judge. Thank you.
Colin, wait, Day, I need you because I need a representative from the state.
Hi.
So here's the deal, Day, and I know that I'm kind of catching you off guard. So this is a DWI, and you're so smart, you're so great. Maybe you can probably shed some insight with us as well. Is that Colin has really tried to get personnel records on an officer in this DWI case. He's been unable to. So for the last 2 settings, I've asked the state to subpoena whoever they can to try to get personnel records.
I think before she left, I think they might have given me a heads up on, because they had the same questions. What's the name of your person?
Castillo.
Castillo? Is it on today's docket?
Yes. I can give you cause number if you
Oh, I
want.
have it, Judge.
So good, man. Just
I figured the docket was pulled up. Okay.
So-
I got the right guy, Judge.
So, yeah, I think this.
What I wanted you, hold on, Dave. I never saw a return on your subpoena.
Mine?
I never saw a return.
Oh.
So what I was looking for first, was there a return? Because it didn't even occur to me when you were here with them, is there even a return on file? I didn't see one.
I don't know if she did court process or. she sent it over
So
to
basically, it's not been served. Number one. Number two, and what I was thinking was information is public information. Like if you go to sheriff's office, they have an HR.
Well, right.
No. Who is in charge of the custodian of records? So what I would do is go to like some HR, the sheriff's office has to have some kind of HR where they list who works where, and a lot of that times that stuff's public information that sits on a webpage somewhere. So
So you're right. It depends on the category of things, because there are some things that are privileged, some things that are confidential, some are core work product. I don't know. in terms of the level of disclosure, but this is outside of what the trial bureau originally gives. I saw that they already sent the notice. So the notice part you have, it's
Right.
trying to reach in the notice and trying to figure out what records.
He doesn't want like addresses and stuff like
No,
that, just
but-
disciplinary issues.
But part of it is whether the, again, this is me
Sustained.
speculating. So so if they're cleared, then that's different. If it's sustained, obviously, everything just goes out.
Right.
And so I don't know, and also part of it, if their impressions, like how much of it is IA, how much.
I mean, think about it like when a lawyer gets in trouble, right? And you get a public versus a private reprimand. So
And that's the issue though, judges, because I've had cases where stuff got shoved into the G file complaint. And when it finally came out, it blew up that officer's career.
So
Like,
if it gets to a point where, and number one is assuming that those records exist. I'm assuming that they are, but I can't confirm. I don't know because no one's
sure.
anything.
So but how do we get them to even get the file to him?
So my opinion, I guess it would be my professional and personal opinion, is did the state trial bureau did they already subpoena themselves as well?
No, they haven't subpoenaed anything.
Okay, so
What I was suggesting to call in is figure out who the custodian of records is, do a subpoena here, 10 days with that person, because on the subpoena he did, it says unknown employee.
right, because there's different custodian of records for different things. So
Person.
My paralegals,
I think it was with Morgan. Don't hold me to it, but
it would be McKenzie or maybe more.
Before, I'm saying before.
Yeah,
It's been moved, by the way.
right, but before she was moved, I think, if I remember correctly, this is the case that we're talking about, is that if we send our own subpoena, maybe she did it before she got moved courts, is if we send it a subpoena, I don't know if that would expedite things having both.
I asked him and it didn't get done.
They didn't get that,
Yeah,
okay.
judge
So
asked twice to have.
at that point, that's a chief court problem, but I don't want to get into the personalizing. So the legal case solving part of it is whomever first successfully gets served, because legally speaking, if no one served the person to respond, then nothing has compelled them to do so. Because I know a lot of the agencies is they won't unless there's a court order. It's not like they're going to fight it. They just want cover for a court order or subpoena to do it.
Who?
And this
Right.
might be more of a general question, but because I've run into this before where the return hasn't been turned in by whoever served it.
To figure out, right? But as looking here,
Well, if there's at least a general person, like for example, in general litigation, I accept service for the office.
Sure.
So like, I'm sure there is a front
There is.
general
Yeah, and
that can reroute it to the correct, because everybody has a central agent, just like I am in general litigation for the DA's office. Everybody has some sort of central, division. And so it's a matter of number one, actually, whether it's defense or state that successfully subpoenaed. And at that point, once you isolate it, then have a set date, because subpoenas presumably by the next, what is it, 16th? I don't know if that's, well, it could be enough time if it's personally served. So if it could happen today, with whomever the new prosecutor, I haven't had the pleasure of meeting the, to actually do it, going up the chain, because everybody has bosses, I have bosses. And so whomever is able to facilitate that going out. But what I'll do is I will email, since we approached, and I don't want it to be lost in the ether, is I'm going to email approached with DC after docket or trial bureau docket ended, as I was here for fugitive docket. Discussed the issue of subpoenaing custodian of records at HCSO for officer file. Court stated that state never subpoenaed before prior ADA was moved from this court. I emailed ADA Watson. No, there's more than one Watson. God. M. Watson. No, there's more than that. God. Z. Watson and Chief of the Court, Kelsey Siegler, on progress. Next setting is January 16th, 2025, I guess. Off docket docket with DCI trial ended. So it's here for fugitive docket and court needed representative from the state. Okay. All right, so I'm here because state needs to be here, but different totem pole, I can't interfere in trial bureau, you know? So let me.
I'm here because Judge asked me.
It's because I wanted to let you know that I never saw a return, so that you're not, because I think it's important to you that,
Absolutely right.
because
I'll double check. And she served it.
Yeah, so I'm
Sure.
emailing
I'll
people.
figure that out.
UCC day, if you haven't already.
Well, for this email, it's going to be internal because I imagine they're going to want to figure out with what happened with Morgan before she left. So at that point, it's going to be internal
They know,
communications,
yeah.
right? But in terms of the notice, I'm gonna, as soon as I figure out I spelled it correctly, which I didn't because that's a typo, I hit enter. So now it's preserved. Can't undo it. It's permanently my notes.
Okay.
So please see.
I appreciate that.
So where do we go from here?
I think I'm going to move it out a little further. I'll figure this out about who to get served and make sure that's
That's
done.
the most important thing, is we need to figure out who and how to figure out about,
I'll get it done, Judge.
Okay.
yeah, I mean, it's, hopefully we can get it, or you. That way we can finally get going,
Okay. So I emailed them. So now it's permanently there.
Okay.
Okay.
All right. Thanks, Doug.
Yep. Thank you.
Thanks, Colin.
Okay.
Hey, Judge, he doesn't want to pull the waiver today because he wants to confirm with the family that they're going to come in. So can we roll it to tomorrow so he can call it tonight? Okay, we'll roll it to tomorrow.
Yeah, that way he can make an informed decision as to whether.
And be sure that the family's going to post the $6,000. Okay.
Hey, follow up. Why do you hate me? I'm just kidding.
No.
Let me email right now.
Can you come tomorrow?
Yeah, I'll be here tomorrow.
Okay, cool.
Okay. Alrighty.
Appreciate it.
Thank you.